So my name is Peter To. I'm the Executive and Artistic Director of Music Africa. And of course, for those of you listening, Music Africa is the organization that puts together the Afrofest Festival, which happens every year. But unfortunately, due to the pandemic, we will not be having an outdoor festival this year. However, we're going to do something, a virtual festival. And in the spirit of doing things virtually, we have this series of workshops prepared for you. And the aim of doing this is kind of to use this as an opportunity, considering that most things are closed, we can share some information that we have and bring talent from within our community and from outside our community to share some of their experiences, give artists and those within the entertainment industry, just give them some ideas and share some knowledge with them that they can use to advance their careers. Everything we do would not have been possible without the help of various organizations. So we have TD Canada Trust, Factor, Ontario Creates, the Toronto Arts Council, and the Ontario Arts Council. They're all organizations who have sponsored or who sponsor us year in, year out, and enable us to present our programs. Now, I have today we're going to be talking about music law, and see, when I put the call out that I would like to do something on music law, somebody that I respect very dearly told me that Byron is the guy that I need to speak to. So sometimes you can go off personal experiences, but if somebody has said this is a go-to guy and you respect the person who is giving you that reference, then of course you're going to respect the person who is going to give the talk. Sent me his resume. It's pretty impressive. I've seen some of the work that he has done. Byron Pascoe, and I'm not going to say much about him because I know he's right here and he's going to talk about himself. And then Lindra Griffith, she just got introduced to me today, and I appreciate the fact that she has made time, being experienced within the field, to come and share some of that experience with us today. So I'm hoping that we all can stay and gain enough knowledge as possible from our guest. Thank you very much. And take it away.
Thank you, Peter.
Thank you.
So my name is Byron Pascoe. I'm here with my colleague, Lindra Griffith. We're both entertainment lawyers with the law firm Edwards Creative Law. We both live in Ottawa, but we work with clients all over Canada. And before we begin, we need to say that this discussion is for information purposes only and is not to be considered as legal advice. Please consult with a lawyer if you wish to apply your specific circumstances to these matters. I'll briefly, actually, Lindra, can you introduce yourself and tell us a bit about you?
Yes, so as Byron said, my name is Lindra Griffith, and I'm an entertainment lawyer with Edwards Creative. And I've been practicing now for quite a few years. And I'm happy to be here and to share some legal information with you all.
And so I'm going to jump to a PowerPoint in a second. We're going to go back and forth between the PowerPoint slides and the discussion. There'll be discussion throughout, but I'll go back and forth between the PowerPoints and us. But definitely want to encourage you, if you have questions, just to put them in the chat so we can discuss them throughout, or you can either raise your hand or use all the Zoom technology, because we want to make sure that this is as interactive as possible. Most people who will view this are people who will not be seeing it live, but for the people who are here live, you have the opportunity to ask questions, which we will aim to integrate into the presentation. And at the end of the presentation as well, we'll have time for questions and answers too. Just briefly about my background, I used to be a television producer, then went to law school to become an entertainment lawyer, and have been practicing entertainment law for about 8 years, mostly doing music these days, not only music, but mostly working with recording artists, producers, managers, music companies, festivals, music business entrepreneurs, that sort of thing. And yeah, so Linda and I are happy to be here, and I'm going to jump over to the slides, and we'll come back to us in a bit, but you will hear us throughout. So I'm just going to press from the beginning. And Peter, if you could just give me a thumbs up that we can see the slides here. Awesome. Okay. So again, yeah, happy to be here. A pleasure to be here and to be part of the program. And here's the agenda. So we already did intros. After that, next, commonly asked music law questions. Then we're going to chat about music agreements, both with your team and with people outside of the scope of your team, and questions and answers. So let's just jump into some commonly asked music law questions. And these are questions that have kind of developed over time when doing presentations. That's why they're commonly asked. That's the name of the section. So what is a music agreement? Well, it really is an agreement between one or between two, at least two different people or companies that relates, generally speaking, to somebody's intellectual property of their music. They might be giving someone the right to distribute their music. They might be giving someone the right to be involved in the compositions that they wrote. Perhaps it's for an event. Perhaps it's to manage somebody. We'll get into some examples, but at the end of the day, a music agreement is just like any other agreement. It's just that it's with respect to your music. What makes, and Linda, I'll jump to you in a bit, but I'm gonna roll through a few of these. What makes an agreement a legally enforceable agreement? So here in Ontario and beyond, a legally enforceable agreement means that there's three different elements of the agreement. There's what's called offer, acceptance, and consideration. And what that means is that the first two are a bit easier than the third. Someone's offering to do something, another person is accepting to do that thing, and consideration means they both get something out of it. It does not have to be fair, does not have to be, well, fair is kind of the main thing that doesn't need to be, but both sides need to get something. And so a lot of the time, not a lot of the times, but sometimes you might find that there's an agreement whereby you're being given $1. And it seems like that's a little bit ridiculous, but the reason why you're getting that is because the person who wrote the agreement wants to make sure that it is a legally enforceable agreement and you're getting something, even if it's just $1, to signify that consideration has been met. And a related question is, well, what's the difference between a verbal agreement and a written agreement? And generally speaking, there's a few things that are well, a verbal agreement and a written agreement can be both legally binding agreements. The challenge with a verbal agreement, whereby you and somebody else are just speaking about something and not documenting it in any way, is that people forget, and sometimes people lie about what they agreed to in past. And so both of those things are dealt with in the context of a written agreement. Generally speaking as well, a written agreement would cover more stuff than would be in a verbal agreement. Linda, do you have any comments about those few items so far?
No, go ahead.
Okay. Sounds good. Okay. So copyright, what kind of copyrights are relevant with music? So in general, there's two different types of copyright that are two different things that are subject to copyright protection. There's a song and there's a recording of a song. So the composition itself, for example, collectively the beat, the melody, the lyrics, there are rights that are generated with respect to that underlying composition of a song. And there are also rights with respect to the recording of the song. So for every song, there might be none, one, or more than one actual recordings of that song. But once you write, once you create a beat, or once you create lyrics, or all of that combined, or a melody, collectively that's a composition, and there are rights that are associated with that composition. If you or somebody else were to record a recording, like a master recording of that composition, there are rights in that actual recording as well. And if you think about it, some of the more famous songs that are out there have many recordings, but kind of one main one that may have come from the original artist. And there are many compositions that are written that are never actually recorded, just because not every song that's written is ever recorded. So there are rights associated with both the song and the recording of the song. And kind of the related question that music lawyers tend to get a lot is, well, how do I copyright a song? And really, this relates to the concept that if you have an idea for something, whether it, for example, a song, if you just have a kind of if you're humming something in your mind, or you're thinking of some words in your mind, that's not protected. What is protected is the work once you've actually created a tangible version of it. So once you've written it out on paper, or once you've typed it up on your computer, or once you've made a recording of it. So there has to be an actual tangible thing done in order for this idea to gain protection. And once you gain protection, what that gives you is what's so-called a bundle of rights that allows you and you alone to do things with that work, that song, until you give the rights to somebody else. So if you have an idea for a song in your mind, not protected. If you write it out, or you kind of record it on your iPhone, there's protection in that work, and that means that no one else can do the things that you can do with that work unless you give them permission. Anything about copyright you wanted to add, Linda?
No, I just want to reiterate that it really is putting it in a tangible form. And some people I know, when they're being creative, they'll put it in an email or record it, as Byron said, on their phone and send it to themselves, right? So they have a record of when it was created and so on. So it's really putting it in a tangible form that creates that copyright.
And there are different registries of works. For example, there's the Canadian Intellectual Property Office. There's the Song Vault that is run by Songwriters Association of Canada. Those things don't actually give copyright. They don't trigger copyright protection. With respect to the government, it does. If you do register a song with the Canadian Intellectual Property Office here in Canada, what that does is that it gives you additional protections in the context of when you are suing or being sued with respect to the process of who has the burden of proof about who created something first. But so that is good to have, but it's not something that actually gives you copyright. So next, how do I plan for success in the context of music law? My kind of quick answer for this is get things in writing. You might write, any artist might write, let's say, 1,000 songs throughout the course of their long career. And it may be a few hundred that kind of get really considered to be recorded, perhaps 60 or 70 that get recorded, perhaps 2 or 3 that are really financially successful, and kind of the one that's the big one. And you really don't know, when you're writing something or even recording it, which of those, let's say, 1,000 songs throughout your career is going to be the big one that helps to elevate you, to the next level in terms of your career. So plan for success in everything that you do. Any song that you write, any kind of relationship within music, professional relationship you have, think about, how do I plan for success? And, what you can think back to with this discussion and others is just to get things in writing, as opposed to relying on assumptions that you have regarding the situation. So just getting things in writing with people is definitely a good way to plan for success. And is it too late to get something in writing? No. If you wrote a song with someone last year, you can still decide now how you're dealing with it. There's no rule there's no rule that restricts you from dealing with something in the past. Now you can always go back. You can always write something up now, and you would just date you can backdate an agreement to whenever date you want in the past. So there's that, but either way, it's just not too late to get something in writing, so long as everybody involved actually still agrees on something and is agreeing to have an agreement between the relevant people. Most favored nations, MFN. So there's actually, if you Google our firm and go under our blogs, there's a blog that we wrote about this concept of most favored nations. And generally speaking, it's about you getting the same treatment as somebody else, even if you don't know what their treatment is. So if, for example, you're hired, you're asked rather to, perform at a festival, and you're being offered, let's say just kind of random, let's say you're offered $1,000 to perform, and you have no idea what the other 10 people were offered, and you think maybe someone else got offered a bit more than you. One of your responses could be that you accept that $1,000 fee on a most favored nations basis with all of the other performers. So if someone else got offered $1,200 or led to a deal whereby they're getting $1,200, if you were given $1,000 on a most favored nations basis with everybody else, that means that you're supposed to be paid $1,200 as well. It works for a variety of things when you don't know what other people are earning and you want to get the same treatment as somebody else. Lindra, anything to add about those last few items?
No.
Okay. Should I submit to this contest? So I know from experience by writing really hardcore bad contest rules that sometimes contests are not exactly the best thing to do. You just always want to read the rules of a contest, because sometimes being a part of a contest. So I'll just leave it at that. Read the fine print on everything, including on contests that you might apply for with respect to some of your music. Essentially, you don't want to be giving away more rights than what you anticipated. Can I remix whatever I want? No. So if you want to remix something or sample something, you need the right from whoever owns and controls the recording and whoever controls the actual composition. So remix and samples, a lot of people remix and sample stuff all the time. The legal jargon is to clear something. So you're clearing a song to sample it. Lindra and I are not the sample police, and neither is Peter, as far as I know, Peter. And so, we wouldn't stop somebody from doing it. We would just tell someone, well, here's how you get permission if you want to get permission. It's not easy to get permission, and sometimes, sometimes. So if you ask for permission of the relevant people, they're either going to say yes, no, or don't respond. And if they don't respond, you're kind of on their radar now, because now they know that, well, you might, they just may wait for the song to hopefully do well and then come after you after the fact. I work with some of my clients on getting permission up front. And sometimes sometimes we ask for permission, and sometimes we're asking for forgiveness. And generally speaking, if you do a deal, you're probably paying less if you're asking for permission as opposed to asking for forgiveness. And when I say asking for forgiveness, what I mean is that you've sampled a song, and days, months, or years after it's been released and made some money, then at that point you go to the rights holder and say, I sampled your song. I didn't get permission when I released this, days, weeks, months, years ago. Can I get permission now? And, at that point, the people who own the rights to the music will likely want you to pay more than they would have asked you to pay if you had asked, earlier on or originally. So bottom line, right to use the recording, right to use the composition if you want to remix or sample a song. And how do you find out who actually has those rights? Well, you look, essentially, kind of look online. With respect to the composition, you could look at the SOCAN repertoire, which is open to the public to use. You search a song on there. You Google SOCAN repertoire, you put in the name of the song, you see who all the writers and or publishers are. And if there's a publisher listed, that's who you'd contact. If there's one or more writers listed, you'd contact those people. If Peter, Lindra, and I wrote a song together, and Peter wrote 98% of the composition, and Lindra and I each had 1%, you'd have to get permission from Peter, Lindra, and I to use the composition. So it's not kind of a majority rules thing. You have to get permission from everybody who owns a share of something. We could talk for an hour about any of these things. So we're just kind of scratching the surface on some of this stuff. Lindra, do you have anything to add about samples?
Yeah, I would definitely add that If you are going to sample a song, and if it's a song that's very important to you, I would strongly suggest getting clearing the rights before you invest any considerable amount of time and money into the final product and the recording, just because you don't want to put, I guess, all those, the eggs in the same basket, and then ultimately perhaps not be allowed to use the sample or that portion of the song. So it is, it's risky to do it the other way around, to ask for forgiveness, but obviously people do it all the time. But I would strongly suggest just trying to clear anything before any significant amount of resources are used.
Yeah. And if you're just playing around with it, and you're not actually going to exploit it publicly, you don't need to get, it is infringement, but it's not something that anyone's going to know about. If you're just playing around with something, it's a way to learn how, if you're just kind of playing around with stuff. But what we're talking about is when things are actually being used publicly and you're, putting it up on platforms.
Yeah.
How do I legally perform in the United States? You get a P2 visa. You can work with the Canadian Federation of Musicians or an immigration lawyer. Linda and I don't do that, but we refer people to relevant people to help. What are your expectations of me and my music? This is kind of one of my little music mottos. I wrote a blog called, what are your favorite 9 words? And it's these ones. It's a really good way to start a conversation with somebody that you're working with, to get a sense of what everybody's actually thinking regarding what the deal is between all of you. So for example, if an artist is working with a producer and the producer says like, don't worry, we'll figure everything out. Don't worry. So you can just actually ask them what their expectations are of what, of you and your music. What do they think that they're entitled to? And it's not an unreasonable question to ask, preferably earlier than later. What do music lawyers actually do? So typically we spend most of our time reviewing music agreements and writing music agreements. Simple as that, ish. And other stuff too, but really a lot of it is contractual. We're writing contracts, we're reviewing contracts that relate to music. We're going to get into some of those things. When do musicians engage lawyers? Usually when they're first asked to sign something. But it's good to have a relationship with someone, in advance. So you're not kind of scrambling the second that you have something that someone's asking you to sign. What organizations, collection societies exist, and why should I sign up? And this kind of is related to the next question of what other music revenue sources exist. The way I kind of frame it generally is that there's, for the most part, 3 different buckets of music royalties when music is being distributed. There's money generated for you as a writer, for you as an owner of a recording, and with respect to your digital performance. And there's organizations that collect money with respect to each of those things. And SOCAN does not do it all. They do a bunch of stuff, but they don't do everything. On the writing and publishing side, there's, and we'll get into this in a bit later, but there's SOCAN. There's also, hopefully everybody who's here and is watching is a member of SOCAN. If you're not, then that's, part 1 of your homework. But SOCAN doesn't do everything. It does collect some writing and publishing money, but doesn't collect everything, although they do now have a program called SOCAN RR, reproduction rights, that does do more than the typical SOCAN did before and past. And with respect to digital performance, we're talking about neighboring rights royalties. United States, the relevant organization is called Sound Exchange. In Canada, we have a variety of organizations, including but not limited to MROC, ActorRax, Connect, and Resound, and others that relate to those royalties. It's good to research them and get a sense of what's going on, and we have some blogs about that kind of stuff. What do I need to know about protecting my music name? So oftentimes when someone is a performer, they don't use their real name, they use a professionally known as name. You want to make sure that no one else, preferably no one else, is using the same name for music. So do a lot of research around it. Preferably you're not choosing a name based on, what some lawyer said, but if you have a few ideas for a name that you want to use, then for sure, try to make sure that no one else is using the name. And if you have a name that you've been using and you've been generating, that you've been investing in, something that you may want to consider is registering a trademark in the name in association with music and musical services. What are different business organizations that I can use? So the last one is about kind of how you actually, what kind of business organization you have. Here in Ontario, and Canada, there's a sole proprietorship, which is you carrying on business as a certain name, but the business is you. There's a partnership. So let's say there's 2 or more people working together. For example, a band would typically be a partnership unless they agree otherwise, or a corporation. And at a certain point, based on tax planning, among other reasons, it's relevant to incorporate a company. Lindra, do you have anything to add about these latest items?
Nope, go ahead, Byron.
Okay, so here, and if you have, again, if you have any questions about things, just let us know. Put it in the chat or in the question thing, Q&A thing. So let's jump to the second, or the next part of the discussion, which is about music agreements. And similar to the last section, we could talk for half an hour about all of these things. We're really trying to focus on some of the key takeaways with respect to these types of agreements, and also just so that they all exist. These are not the only types of music agreements, but these are 7 of them, 7 of the more popular ones, or at least the more common ones. So let's jump right in. So the first one is a co-writer agreement, also sometimes referred to as a split sheet, if it is a split sheet. And one second here, here's what it might look like. And if you email us afterwards, we can send you a sample split sheet that in part looks like this. It just doesn't have, it also has some signatures. So just kind of walking through this, if you and someone else are writing a song together, it's a good idea to figure out, as between the 2 of you, what this split is of the composition. Like, how are you equal? Does one person have more rights than somebody else? Just outlining it in writing is a good idea to do. And so the first item here is composition title, where you put the name of the composition. Working title means like the title for now, and it might change. And a lot of songs actually kind of change dramatically before they actually are released. And in this sample here, I wrote what the credits are, who's the performer, who's the writer, who's produced by. Something that I added into this split sheet is the master. Like, if this assumes that there is a recording, and it says who owns the recording. And then you list the writers. PRO is Performance Rights Organization. So here in Canada, it's likely to be SOCAN. Most Canadians who are writers are a member of SOCAN. IPI is a number that you're given no matter what PRO you're attached to throughout the world. So in the United States, there's the main ones are ASCAP, BMI, and CSAC. There's actually one more too, but most countries around the world have a performance rights organization, and the IPI number is what you get no matter what PRO you're with. So if you're a SOCAN, you have an IPI number. If you're in Japan and you're a member of JASRAC, you have an IPI number. Those numbers work, like there's a system throughout the world that connects all together. And then you have the share. So let's say, if it was Peter and Lindra who wrote a song together, then in the writer section here, it would say Peter and Lindra. It would likely say SOCAN for both. It would have their number, and maybe it's 50-50, or maybe it's 53-47 or 99-1. Whatever it is, it adds up to 100. If it adds up to more than 100, you got a problem. If it adds up to under 100, that is also not good. So you want to have it add up to 100. If there are publishers involved, then they'd be listed as well. But an individual is you are your own publisher, unless you bring someone else, unless you assign or license rights to somebody else to be your publisher. One other comment about SOCAN is that you can sign up with SOCAN as a writer or as a publisher. If you're a publisher, it can't be your actual name. It can be a sole proprietorship. So for example, it could be Pasco Publishing, and I got a a name search and a name registration with Service Ontario for that, and then I register it with SOCAN as a publisher. It's not an individual, but it can be an individual's company that is not an incorporated company. Either way, the main thing here to take away is that if you're writing with somebody else, something to think about is having a split sheet, which at its core outlines what the allocation is between the writers involved. If you're a producer, you can easily be considered a writer. If you are sometimes this is what's called the Nashville split. Essentially, like anybody in the room at the time is an equal writer, but just because who writes lyrics, if someone writes a beat, they might be considered a 50% writer. If someone's in the room and just kind of sharing their vibe, then you may decide to give them something too. If someone's a producer, they can also be listed here. So even if someone is not actually writing the song, they could be listed here. And sometimes people do that. Don't tell SOCAN, but sometimes people do that just as a way just to allocate, royalties between them. Lindra, anything else to say about a split sheet?
Yeah, I would say that split sheets are great, or any type of agreement or breakdown of how the rights are to be distributed in advance is always good. I would also say that if you were to, I guess, keep in mind that things can change as the song evolves. So you might enter into a split sheet with a co-writer, but then later on you decide to have it have someone else add something, or producer, or just add some arrangements. Well, then the composition has now changed, and that that contributor may have some rights. So you may have to change the split, or change your split. You might have to rework the split sheet, but it's a good place to start. And just keep in mind that as more people work on a song, it might evolve. So it's just something to keep in mind.
Yeah, really important point. I'm glad you made it. Things do change for sure, and you want to make sure that everybody agrees, to the change. If you want people in, and this simple split sheet here does not cover other royalties like from the actual recording. This really focuses on just the composition itself, and a lot of times that's fine, and sometimes that's not enough. But this is really at its core about splitting the composition. The whole master owned by line is, could mean, well, it means who owns the recording. It doesn't say though, what the entitlements are of the other people from the recording's royalties. It just says who owns the recording. Okay, so jumping to producer agreements, and really kind of the way that these agreements were set up here is in part, at least, about like what's more common and what's less common. So, and for every song, unless you write it yourself, if you're writing with somebody else, you should figure out what the split is between you and the other writer or writers. Many songs that are written end up being produced by a producer. And so, less common than split sheets, but more common than other agreements is a producer agreement. And it's probably the most common agreement that I, prepare or review for people. And the top line is really kind of the big takeaway, that the conversation with your producer should be more than what amount of cash is switching hands. And, I'm assuming that people watching this now or in the future are both, some are producers and some are artists. And we work with artists and producers, just, not if they're working together on a deal. But a lot of clients are producers, a lot of clients are artists. And that's, we're not like one or the other. We work with both. And, these comments here are not really, only geared for an artist to hear or a producer to hear. It's important for both producers and artists to have a better sense of, what the deal might be between an artist and a producer. So again, it's not just about how much money is being given. It's about a bunch of other things too. But regarding the amount of money that's being paid to somebody for their efforts, generally, an artist paying a producer to do the work, to record it, to provide perhaps mixing and or mastering services, to give their input on kind of the feel of the song. If they're paying a fee, well, when is that fee being paid? Is it being paid part upfront, part later? The later, is it when it's been delivered or when the artist has accepted delivery? That's a big distinction. So, clarifying what amount of money is being paid, also what currency it is, especially if you're working with an art producer outside of Canada, and what's being paid now, what's being paid later, and for anything that's being paid later, what triggers that later payment, and also what triggers the first payment. Is the first payment after a simple agreement has been prepared? Is it right now, or is it within 10 days from now? Like, whatever it is, it's important to discuss that so both parties don't have inconsistent expectations about when money is being paid. Second item here is about the composition. So, is the producer being given a share of the actual composition? What is the producer paid now? What are they paid later? So we talked about the now. What about the later? Are they given any percentage of royalties from the recording? Are they being given any percentages of money generated from the digital performance? And I mentioned before, sound exchange and neighboring rights royalties. So is the producer getting any of that? Is the producer getting any money from music placements? There's no right answer to this. It all leads to the typical lawyer answer to any question of it depends. It depends on the circumstances. If you're dealing with a really big name producer, and they have higher expectations than someone who's just starting their career as a producer. If someone created the beat to your song, it's likely reasonable that they're paid more now and later compared to somebody who's pressing the record button on a song. So the role of the producer, and there's nothing wrong. Like, I'm not trying to say there's something bad about just pressing the record button. There's a lot of things that a producer can do, but there's different types of producers that do different types of things. And so what they get paid and how they're credited, the next one, really depends on what they're actually doing, what the relationship is between the parties, and all the things connect to one another. So for example, the more money you pay a producer upfront, perhaps it's more reasonable that they get paid less later. And the related point is that if you're paying the producer nothing now upfront because you can't afford their time and services, likely it's reasonable that they get paid more of future potential sales. So there's really a balancing act of how all of the elements of a producer agreement interact. One of the key things is, generally speaking, that the producer is providing his or her rights in their work and the recording to the artist. So the artist owns the master, but the artist has obligations to pay the producer from future royalties that are generated. So when an artist and a producer just kind of talk about their deal, what I generally say is, well, where is it in writing that you, the artist, owns the recording? And it's probably not discussed. And it is one of the key elements of a producer agreement that somebody, it could be the producer, it could be the artist, it could be that they both share it in a certain way. All of those three things happen. It depends on the circumstances, but it's really important to clarify in writing who owns the recording. Linda, do you have anything to add about?
I would just add that that too can change. And at the time of a producer agreement, you may, as the artist, own the master, and then eventually get picked up by a record label, and then you assign basically those rights to the label, and the label would then potentially, depending on what the agreement is, of course, may own the rights to that master. So.
Yeah, exactly. And the label is going to want to see that, as between the producer and the artist, that the artist owns it, and then the artist has the right to either assign ownership to a label or to license certain rights to a label that we'll get into in a few slides from now. And so, because of that future arrangement between an artist and a label, the artist needs to make sure that he or she actually has the rights to give to somebody else. So let's jump to band agreements. Similar to producer agreements, if you go onto our website, there's essentially a blog about all these things. There's a blog about band agreements, blog about producer agreements. In the blog about band agreements, there's about 50 or 60 questions that we wrote. Maybe should be updated. It's been a while, but questions that a band should think about, and really. And I'm not suggesting that you go onto our website, answer the questions, sign the agreement, and that's your band agreement. However, it's a good starting point to discuss the details of a band agreement as between the people in a band. And, depending on the group, depending on kind of the genre as well, sometimes the band may be an actual, like they may collectively own stuff, or maybe that there's a main person who hires the other people. And that's really a different situation compared to when there's a, let's say a rock band, there's 5 of them together. They, may co-own stuff. A lot of things may be equal between them versus, let's say you have a hip hop artist who hires his or her on stage DJ. The performer would not want to have things be considered as if they're in a partnership with their DJ, unless they do. But or maybe a country singer, she might hire a person who plays guitar on tour with her, and a drummer and a bassist and whatever else, but like it's actually her band, it's her music. She's just not just, but is hiring people as side artists to perform on recordings and on tour. What we're talking about in this context is where you have an actual group of people, whether it's 2 or 20. Gets more difficult when there's like 20 people, but who are actually collectively deciding that they are going to act as a partnership. They're going to figure out their responsibilities between them. They're going to figure out who makes decisions. They're going to decide just about the music itself. Like, does anyone have creative control? How are creative decisions made? How's money being split up? It doesn't have to be split up equally for everything. Next comment is the same thing about royalties to band members, band assets. Who owns the name of the band is a really big one, especially in the context of things ending between band members. What is the process for new and former people to come in and people to leave? What happens if the band dissolves? And most bands do break up at some point. Co-writing aspects, how you're dealing with co-writing royalties. So a bit of repetition here. Negotiating with others on behalf of the band. So, can one person make decisions on behalf of the band? Music placements, again, who's kind of making decisions? Should we set up a SOCAN publishing company membership? I kind of generally do recommend this so that there's one entity. If you're not working with a publisher externally, then it may be helpful to have an actual publishing company that the band owns, but that one person makes decisions on behalf of that publishing entity, which kind of make things a little easier, especially if someone leaves the band. So these are some of the starting points of discussions. If you want to have a band agreement, you don't like call up a lawyer to get a band agreement. You like talk to the band about these kinds of things. You can get a lawyer to help early on, but really, the key point here is to have a discussion with the people you're working with regarding these kinds of things. Big ones being, control and money, and it's a lot easier to share money when there isn't any yet. So it's easier to figure these things out before you actually have kind of big decisions to make. I've literally done less band agreements than like every other agreement, just because so many bands think they don't need it until they do. So, Lindra, do you have any comments about band agreements?
Yeah, no, I was going to say definitely you can consult a lawyer for band agreements. I've done them, but I would just add that absent any agreement, so verbal or written, the members of the band ultimately they all share equally everything without, I mean, because it's essentially a partnership and an equal partnership. So unless there's anything specific that, says otherwise, I believe that's the default. Right,
Yeah,
Byron?
and you're referring to, like, what Linda is referring to is the Partnership Act of Ontario, and throughout whatever province or territory you're in Ontario, we're not going to speak about U.S. law if you're watching from the States, but here in Ontario, there's the Partnership Act, and this act governs your partnership unless you agree otherwise to overtake the default of the act. And if you're working in business with people to make a profit, then you are likely considered by this act, this law, to be in partnership. And the Partnership Act refers to things Linda was talking about equalness among the partners. And the reason to have a band agreement is that it circumvents, or rather like overtakes, the default of the Partnership Act, because you probably, more likely than not, you don't want the Partnership Act, which you've never read, by the way. You like, who's read the Partnership Act? Like, some lawyers, but not, everyday people don't read the Partnership Act, let alone have heard of it. So you want to overtake the default of the Partnership Act by having an agreement. It can be very simple. It can be more complicated. I mean, nothing, let's say, is complicated, but it could be more intense. It could be more simple. It could be on a napkin where you have 4 little pieces of a pie and you put each other's name in the whatever. I mean, I don't recommend that, but it's better, that may be better than not talking about it at all. So, there's kind of classic stories about, agreements on napkins. Those are generally, or a lot of them are, band agreements. So, again, we don't write agreements on napkins, but if you did, at least it's, it's better than not talking about it at all. Online concert agreements. So a lot of discussions as of late through COVID have been about the concept of concerts that are online or are hybrid of like in-person and online. And that's probably kind of the next phase, depending on when you're watching this. Today when this is being discussed in March 2021, living in the past, March 2021, there's a lot of concerts that are happening online and online only. And what we deal with as music lawyers is working both with festivals and with performers with respect to online concerts. And so here's some considerations that are kind of relevant for that kind of agreement or arrangement. Some of them are the same as kind of in real life, like an IRL concert, but this is from an online perspective. So what are the key show details? Like what is the length of the show? When is it happening? Like just general logistic stuff. Is it online or hybrid? Hybrid meaning both online and in person. What's the revenue model? So, is there a guarantee? Is there a share of sales of tickets? Generally speaking, there's more money involved when it's an in real life concert as opposed to online. And so, it's a relevant consideration of what the revenue model is. Is it public or private? So by this, I mean, like a private would be like, let's say a company or a promoter comes to you and says that they want to have a show for a private company. So people can't publicly buy tickets, or it's public, so anybody could buy tickets. Live only or stay online on demand. So it might be online only, or it might be available for days or hours, days, weeks, months, years after the fact. And preferably as an artist, you probably would prefer that it doesn't stay online for too long, because that may impact your ability to do other online concerts. Is it recorded live or pre-recorded? And pre-recorded is sometimes called fake live. And so, again, are you actually recording it live when if the concert's for, Saturday at 8 p.m. Eastern, are you actually performing at Saturday, 8 o'clock Eastern? Or are you preparing it in advance and it's going live online Saturday at 8 o'clock? So that's important to know. And some people prefer fake live, some people prefer live. To each their own. Who's the host platform or tool? So is it Zoom? Is it Side Door Access? Is it YouTube? Is it Instagram? Is it Facebook? Is it Twitch? What is it? important for everybody to know what tool and platform you're dealing with. Is it going to be geofenced? Like, is it only accessible to people, for example, in Canada? Or is it available to anyone in the world? And this relates to the next one, which is a radius clause. Similar to in person, is there any sort of limitation on when you can perform next or beforehand? Like, are you able to perform 2 online concerts at the exact same time? Which gets a little weird sometimes if, if 2 organizations or festivals are having the same artist perform and it's at the exact same day and time. Clearly one or both of those are fake live shows. And if you are making it seem like it is actually live, then you probably shouldn't have a performance at the exact same time that is also allegedly live. So these are, again, like some of the considerations. What this doesn't go into too much is the actual royalties that are relevant in online concerts that are not relevant in real life, in-person physical concerts. And it generally relates to the compositions. And that is a whole, presentation on its own that I've done a variety of times. And really, it's important to, if you go to our website, there's a couple blogs on the topic about online concert royalties and licenses. It's not really the focus of this presentation. So all I'd say is that there are other considerations when you're doing online concerts relating to the songs you are performing. It is a lot easier if you're performing original songs that you wrote in control as compared to songs that you wrote with other people or that are cover songs that other people wrote. So like our context at the law firm is we work with both festivals and performers, more performers than festivals. But when we're working with festivals, some of the things we do these days is helping with their online concert agreements. But, even post-COVID, there will likely be more online and hybrid concerts compared to, pre-COVID. Because we've seen we're able to reach, the world a lot easier digitally, and people, accept it, even though they'd rather be in person. So it's important to kind of know moving forward about how online concerts work and about, the technical and all that stuff is obviously extremely important, has to sound and look good. But, from where we're concerned, it's about, what the agreement is between the parties. If you're being asked to perform at an online festival or for a show, and they don't really give you any of these details, then these are the kinds of questions to ask about. These points here aren't only for if there is an agreement, it's also for if there isn't an agreement. So you have some additional things to think about or to ask about. Lindra, any comments about either like concert agreements in general, performers that are being asked to perform at a concert or rather a festival, or with a promoter? Anything to
No,
add?
I was the only thing I was going to add was when you made the point that it's a lot easier if you're the songwriter as opposed to covering a song, and I was just going to say it's also it can be more lucrative too.
Yeah, for sure. You definitely keep the royalties yourself. And there are programs these days, for example, Facebook and YouTube, they have their Encore program that is a relief program whereby if you perform a concert on Facebook and you have a certain amount of metrics that you've met, you're able to access, I think it's $150. If that's wrong, I'll correct it afterwards, but $150 that goes, towards the songwriters of the songs you performed. So if you're performing a concert every, 2 weeks, and you're performing your own stuff and it's on Facebook and you're meeting all these guidelines, then you can, through this program, Encore, get paid an extra $150 per show that's going towards these songs that you wrote. If you didn't write any of these songs, then other people are getting paid, not you. So that, there's different relief programs like that are out there to help to put some money in pockets of performers at this, difficult time. So that's one of them. Management agreements, there's the key thing about a management agreement is if you're an artist working with the right person as your manager, and if you're a manager, the main thing is having the right person as the artist you're representing. More important than anything else in a management agreement is that it's with the right person. And so whenever I'm asked to review management agreement, I say, well, okay, before I actually do anything, like, let's talk about this person. How do they come about? What's the background? What have they ever done for you? Who do they work with? What's their reputation? Do you want to be professionally married to this person? Because it essentially is a professional marriage, unless it's not, but it usually is. So again, due diligence on your manager and also on your artist. If you're a manager, you don't want to be wasting your time on an artist who's not going to respect you. And if you're an artist, you don't want to be wasting your time with a manager who's going to, do things that you don't like and it doesn't have a good reputation. So I don't mean to sound harsh, but you want to make sure you're finding the right person. And if you have, then you have, hopefully you have a management agreement that outlines the rights and entitlements of both parties. The manager might be an individual. It might be a partnership of two people. It might be a company that the manager works for. It might be a company that the manager owns. So there's a variety of different types of parties, or in groups of people or entities or individuals that may be the actual party that you're entering into an agreement with. When I say party, so that's kind of the legal jargon of who signs an agreement. If two people sign an agreement, they're both parties to the agreement. If 5 people sign an agreement, they're both parties to the agreement. They may be having fun, but it's not like a party. It's a person or a company who's signing an agreement. So an advantage of having a written agreement with your client is that, similar to the other stuff on verbal agreements, you don't want to be in a situation as a manager where you've agreed, verbally to 20%, and then your artist says, "Oh, no, we agreed to 10%." Like, you don't want to be in a situation where you're just, that's probably a bad sign to begin with, but you want to have things in writing so they clarify what your rights and entitlements are, both as an artist and as a manager. Good to have things in writing so people don't, forget or lie. And similar to the earlier comment, usually a management agreement, if it's written by a lawyer and not, the internet, then there are more things in the management agreement than as compared to what you would have thought about, initially. When should they be prepared and signed? Preferably earlier than later, but they can be signed after the fact. If you've been working with a manager for a year, you may at that point both decide that it's time to formalize your arrangement, even if it's already started a year ago, and you can date it, a year ago. Maybe it's a 3-year term that started a year ago and it's dated a year ago. That's okay. Are your services exclusive? So a manager, is the artist okay if the manager represents other artists? Hopefully for the manager's sake, the artist is okay with that. In some situations, it would be relevant that the manager only represents that artist, but typically a manager is able to work with multiple artists. But the artist, like, their only manager is their manager, but the manager might have other artists as artists. So what are your specific tasks and authorities? Like, what is the manager allowed to do? What is the manager required to do? Really important part of the agreement, because it clarifies exactly those things. And you want to make sure you're just being really clear with the other party on what they're doing. Do they have the right to approve, publicity or an individual show or a tour? They're probably not given the right to sign an agreement on your behalf for like a record label or a publisher, but you want to clarify what the rights are of the manager. What's the term? Like, how long are we talking about here? It might be, there's no actual answer on what is the appropriate term that, like, without knowing any information, it's hard to say what it should be, but it's usually in the form of a number of years. For example, 2 years, 3 years, 2.5 years. I guess that's a half, so it's not entirely years, but it's not for like a day, and it's not for your life, and it shouldn't be for a decade, but it's usually in the scope of a few years, and the term may extend. The manager may have the right to either the manager or the manager and the artist have the right contractually to extend the life of the agreement. Linda, do you want to jump in about anything yet?
Yeah, I would say that having it in writing is very important because, as you were saying, the percentages, you want to be sure what the percentages are, what the splits are, but also they can differ depending on what they can differ for different things, and you would want it in writing so that the manager has some authority towards third parties. So often third parties, will only engage or discuss with people that have authority of the band or of the artist, and without some sort of written agreement, they may not. The manager may not be able to engage. Yeah.
A related term to that is called power of attorney, whereby the artist is giving the manager a right to sign on their behalf for certain things. And an agreement would clarify the scope of that power of attorney.
Oh, right. And I was the one other thing I was going to add was that these agreements, Byron was talking about the term and or the length of these agreements, and some of them can be on a trial basis because it could be for a trial of 6 months or a year, and then after that the parties can extend, because these agreements are very important, and as Byron says, it's these are important decisions, and this is a pivotal member of your team, and so yeah, you don't go into these agreements lightly.
Agreed. As I mentioned before, it's like a marriage. Some say you may want to date first before you get married to somebody, so you may want to kind of try working with them until you formally engage them as your manager. And the point about a trial period, sometimes called a probationary period, for example, it might be that during the first 6 months of the arrangement, either side can at any point end the deal without it extending to the full amount of years of the term. So yeah, all these things lead to how do you as an artist make sure that you're protected, and also as a manager, how are you protected? Because you're only going to invest a lot of time into this artist if you know that if you do stuff that you will earn stuff, so to speak. So what exactly are you earning as a manager? So this slide here talks about the compensation that you might be entitled to receive. Are you earning a percentage on everything? Typically, but not always. There's it's essentially like everything except for this, or like gross revenue doesn't include this and this and this. For example, money paid to me that I'm paying to a producer, or money that's paid to me as an artist that I'm paying for an opening act, or money paid to me that I'm using for sound and lights of the show, or that I got from a label towards marketing costs, or there's a variety of things that might be not included in the commission percentage. And as Linda mentioned, the commission could vary. It could be that you get a certain percentage under a certain amount of money, and over that you get a different percentage. It might be that you don't earn commission on the first, $1,000 earned per month or term or whatever. There's a variety of ways that the commission can vary. It can also be a certain percentage for certain things and different percentage for different types of royalties. So it can really be all over the map. Typically, it's usually 1% for everything, less certain things, but there's no. When does the scope of work start? That's the thing. If you've been working with someone for a year now, perhaps you agree that the commission started, a year ago or today or whenever you want. And what do you get for your work after the agreement ends? This is what we're referring to here is a sunset clause, where an artist has obligations to contractual financial obligations to a manager after the deal ends, subject to a variety of caveats in your deal. So the concept is that a manager, if they put in a lot of time for a variety of years, if the deal ends, they perhaps are entitled to keep earning something after the deal ends. So every sunset clause is different. They either exist or they don't. The line I say is that they're reasonable so long as they're reasonable. If you're paying your manager 20% commission during your term, well, if your manager steals money from you and does a lot of bad stuff, and your sunset clause provides that he or she's getting 40% after the deal ends forever, like that doesn't sound like a very good arrangement or reasonable. But there's a variety of formulas that may be reasonable in the circumstances. I'll leave it at that on that. What's the cash flow? Is money from sources that, like Linda mentioned, third parties. So like when we're talking about third parties, we're talking about like a label, or perhaps money coming in from DistroKid or from a publishing opportunity or from a tour. Does money go to the artist and the artist pays the manager, or does money go to the manager and the manager pays the artist? That's cash flow. Like, how does it work? How does it flow from one person to the next? And how do expenses and loan work? If a manager is paying for stuff on your behalf, does he or she get their money back whenever they want it? Just figuring out the deal if the manager is paying for stuff for the artist. Linda, before we move on to record label, anything else to add about management agreements?
No, I think we covered it.
Okay, perfect. So record label agreements. So in 2021, you or anybody is able to get music distributed, internationally, digitally or physically, and you're able to market stuff. You can buy services. You can buy someone who's providing you services to do digital ads. You can hire someone to do design work for you. You can hire, a music video production company. Anyone can do all these things. A label, what they do is they do those things too, but they're typically paying for them. And they're, the concept is that they're doing it better than you could have done. No offense to you as the artist, the label is saying, well, we have experience doing this. We have a whole team of people. We'll do it better. We'll do it better than you would have been able to do on your own. We're going to invest in these costs, and in return for marketing and perhaps paying for recording, we're going to share in the money that's generated for either a small amount of time or a forever amount of time. There's different types of labels that are out there. There are some that are considered major labels like Universal, Sony, Warner. There's labels that have connections to major labels. There's labels that are artist-run labels. There's labels that are shady operations that you want to avoid at all costs. And there's legitimate people too. But really what you're giving them is the right to distribute your music. And what you're getting is support to promote your work and money to make your work. Initial terms and option terms. So what we're referring to here is essentially the scope of music that is incorporated into your deal. Is your deal for one album? Is it for 5? So I'll leave scope at that. Advances, are you getting any money in advance, like from the beginning, instead of waiting later on to earn money from royalties? So an advantage that a label has is that not all of them, but generally speaking, one of the advantages is that they might be able and want to give you money up front, so that you at least have that amount of money guaranteed that you're receiving, even if the music doesn't earn enough or any money at all. Generally speaking, in advance is what's called recoupable but not returnable, meaning that the label pays itself back, the advance that it had paid to you, but you don't have to pay the label back if the music doesn't do well or as well as you all would have liked. Grant of rights. So typically you're giving the right to distribute the music in a certain territory, perhaps the universe, perhaps Canada. You're giving the right to use it for a certain amount of time, perhaps 5 years, 7 years, or forever. And you're giving them the rights in a certain type of media, for example, all digital or all physical, or is everything now known or later invented? So that's kind of the quick summary of the grant of rights that you're giving. The revenue model really depends on the circumstances, like anything. It might be essentially what's called like a profit split. So after some expenses are paid off, you're perhaps equally sharing money with the label 50-50. So if $10,000 is generated and the label had $3,000 in costs. The label gets their $3,000 back to them. And of the $7,000 remaining, you get $3,500 and the label gets $3,500. The other model is a variety of things, including what's called a purchase price to dealer, PPD, whereby you're given a percentage, a much smaller percentage than 50 of sales overall that for which the label sells the music. Typically, your share is less some or all of the expenses that the label pays for. Release and marketing, you want to make sure that if you're doing a deal with a label that they're committing to releasing your project within a certain amount of time of when you deliver to them, and that they're committing to a marketing plan and budget. Because again, like if you enter a deal and they never release your music, well, that's not good. You don't want to be shelved by a label, and if you do, you want to be able to get your music back. And you're doing the deal with them because you want them to, spend money and resources on marketing it. So preferably they're committing to what they're going to do. And the last point here is about breaching the agreement. What happens? So preferably your record label agreement would outline what happens if the label doesn't do what they're supposed to do. So, I mean, these are just 7 really, quick and dirty, overview points of a record label agreement. A label agreement might be 1 page or, 100, kind of depends on the circumstances, but really it comes down to these key things. And similar to a manager, it's, when I get a record label agreement to review, my questions are, is this the right label for you at this time with this project? If not, what are you doing? And if so, then are you sure? Why do you want to do this deal? What have they told you? Let's make sure that what they told you is actually in the deal. And let's talk about what's missing. And let's talk about, what we can, how we can respond. And oftentimes when you're getting a label agreement for the first time, whether the label is your buddy's new label or some legitimate operation or a much bigger party, you might feel a little, you might feel that if you ask for anything that they'll be offended. But this is kind of it's a normal kind of dance to play, that you get an agreement, they know you're going to push back on some stuff, especially if you have an advocate fighting, in your corner, whether it's a manager, an agent, or a lawyer, or a parent, like a momager, mother, manager, mother. Someone's asking questions, someone's pushing back on some of the things, and it's a normal process to do. But as an artist, especially the first time you get one of these agreements, you may feel like, the label's not going to like you if you ask questions. And, that does happen sometimes. But if a label, says this is a take it or leave it deal, and we're not answering any of your questions, we're not going to, allow for any changes at all, that's probably a bad sign. Not always, but, it might be at least a red flag that this may not be the right partner because they aren't even, listening to your initial questions. So we deal, in Canada, we deal with our clients, our Canadian clients who have deals with labels in Canada and outside of Canada, of all shapes and sizes. And it might be for one song, for one album, or for a lot of music. Really depends on the circumstances. Linda, anything to add on this stuff?
No, Byron.
Okay.
Thanks.
So the last deal, I think it's the last deal. Yeah, last deal we'll talk about briefly, or the last kind of deal or agreements, is publishing. And this really relates to the actual compositions that you wrote or co-wrote, and how they are being exploited in the world. And exploited may seem like a really kind of dirty word, but it's just kind of the jargon of how music compositions are used. Maybe that may sound bad too, but how they're brought to the world, and that's a good thing. So there's a variety of potential partners in publishing. 3 of the more common are a co-publisher who's going to likely co-own your compositions with you. There's an administrator whose role is to seek out royalties for your music that you wrote, but not actually likely seek out any other opportunities. And there's a sync agent whose role it is typically to find opportunities to place your music into film, TV, ads, that kind of thing. And they aren't doing any of the other stuff. So a co-publisher does the job of an administrator and generally does the job of a sync agent, but you could also not work with a co-publisher and instead have an administrator and or a sync agent who are helping to find opportunities for you. In all of these cases, the following 5 items are what might be relevant to incorporate into your deal. The advance is money up front, which more likely, if you're going to get them from any of these partners, it would be from a co-publisher, not from an administrator or sync agent, although that definitely is possible and happens. It just kind of depends on the circumstances. And again, this is money you're getting today, which is being earned later on, but you're keeping this money no matter what. And one major advantage of working with a co-publisher, of giving up a lot of your rights, is that you're getting this money, and you might need this money, for rent or for recording your next album or for whatever you need money for. But, typically when we get this kind of an agreement, my question to the artist is, how much money do you need? Because if you need, a certain amount of money from your label and your publisher, then we need to, take that into account. So, it's really helpful to be very transparent with your lawyer about, what your needs are and about your circumstances, so that he or she can help to, meet your needs. Amount of music, if it's an administrator, it likely is kind of whatever amount you give to them. A co-publisher, typically, but not always, it might be every song you've ever written or co-written, and every song you write during the term of the publishing deal, which might be a year, 2 years, 3 years. It might be specific to a project like an album. But generally speaking, it's usually a broader scope of songs that are within the scope of a co-publishing deal. Decision-making, who makes decisions about the uses of the compositions, preferably for you as the singer-songwriter. You get to make decisions, like any decision that would be made by the publisher. Hopefully you get the right to, approve it or not. And an example here is if someone wants to sample your song, they would go to your publisher, and your publisher would either give you the right to make that decision or not. Or if your song were to be considered if someone came to your publisher because they wanted to put your song into a television advertising campaign, preferably your publisher goes to you. Sometimes decisions are made by the publisher unless it's a certain type of use, like, for example, in a religious ad or a political ad or something that's a little like, well, I'll leave it at that. So decision-making is an important consideration to think about. Revenue model, what percentages, what is the publisher getting? What are you getting? Typically, an administrator would take a much smaller percentage of royalties compared to a co-publisher. Typically, but not always, a sync agent would get a share of money generated upfront for a placement. So, for example, if a sync agent says to you, we got an opportunity to put the song that you wrote and you own into this TV show. They're going to pay us $5,000 for the right to use the composition and the recording. We, the sync agent, take 30%, for example. So in that case, they get $1,500 and use the artist get $3,500. That would be generally, but not always, that's like what the synchronization agent would get, and that's all they get. A co-publisher, on the other hand, they would perhaps get, let's say 30% of that fee, but they'd also be earning money when royalties are generated later. Because if the song is, let's say, in a TV show, there's money up front that's paid for the recording and the composition, but there's also money that's paid by the network to SOCAN, who eventually pays the writer and the publisher. So the publisher would be earning money now and later, whereas a sync agent would, generally speaking, but not always, there's always exceptions to the rule, but generally speaking, they'd be getting money only up front. So the revenue model is important to understand. And the role of a lawyer in a publishing agreement is to, advise you on what's normal. Like, is it normal that they're asking for this amount of money or percentages? Termination, a publishing deal usually ends at a certain time unless something happens. And typically with an administrator, it's a lot easier for you to leave sooner compared to a co-publisher. And a sync agent also might be in a non-exclusive arrangement. So you might have multiple sync agents, like multiple people seeking opportunities for you, especially if they're in different territories around the world. So again, I mean, we've done presentations for like an hour on publishing agreements. This is really tip of the iceberg stuff to get you thinking about, what are some key things to think about if you get a publishing agreement, and also just to know like what a publisher is. A publisher is someone who seeks opportunities for your writing, and also typically, hopefully, would connect you with other writers to write for you or for other people. They're really working with you as a writer, whereas a record label is working with you as a performer. And it's okay to have a label arrangement, but no publishing arrangement. That's fine. Like, you can do that. It's okay to have a publisher and not a label. Like, you may distribute your music personally, but you may have a publisher who's helping you to collect royalties or to seek opportunities. It doesn't have to be the same company who's your label and your publisher. Sometimes it is, sometimes it isn't. There's companies out there, for example, like Warner Chappell is their publisher, and Warner Music is, or whatever their legal name is their record label. So sometimes you have companies that do both. What you may try to avoid is, if you're working with a label, if they just kind of add on publishing rights, the question to them would be, well, what would you be doing as my publisher? So a record label doesn't need to be your publisher. They may want to be, but they may not need, but they don't need to be. Linda, do you have anything else to add about publishing agreements or publishing relationship?
You covered most of the surface elements of it.
Sounds good. So, yeah, I mean, we've kind of run through, as I said, a variety of music agreements. These are the more typical ones. Other agreements within music that we deal with are really kind of corporate stuff. Like if a few people are setting up a corporation, we would deal with the corporate legal documentation. We set up corporations for musicians all the time. And other things come up with our music clients relating to relationships that they have with other people or companies. These are just kind of the more typical standard music agreements. So I'm going to stop sharing the screen for a second and go back to us in person here and answer any questions that anybody has. Peter, is there anything you want to kind of kick things off about? Any questions that you think we should cover?
Yes, please. Thank you very much for the very informative presentation. Before we actually, because I have a few questions here, some questions were asked on YouTube, and some people have texted me questions. I don't know why they decided to do it that way. I just have a few points that I would like to add on to what you guys have said based on the experience that I have working with artists. So take, for instance, an organization like Universal. Universal goes out and looks for artists. So I think previously artists could send their music to Universal or these major record labels, and they will select from the bunch. But now the larger music labels actually go out and scout artists and say, okay, this is the artist that I need to work with. They no longer accept resumes or music. So why this is important is because if your contracts are not, if you don't have any contracts and you have got a lot of music out there, the record label is going to be asking who has the rights to your music. And if there is nothing out there that they can define or that they can hold on to, then it's going to be more difficult for them to work with you. So even though right now nothing is happening, it is important that these elements within your organization are taken care of, so that when the time comes, you would be ready. Then the second thing is Byron mentioned SOCAN. Now, artists get paid, say if they come work with us, we pay the artists. But also on the flip side, we pay SOCAN a fee every year for artists. So I don't know if the artists are making use of that or contacting SOCAN to say, hey, I performed at XYZ event. Could you guys pay me for XYZ songs that I did? If not, then I think that's a lost opportunity. And as artists, you may want to consider that. And then the third thing, before I start asking questions, is I think a lot of artists they make a mistake. I'll not say mistake, but they overstretch the definition of manager, and they expect their manager to take care of marketing. You see, most artists are sole proprietors. So one thing I usually when I talk to artists, one thing I ask is, what is a manager going to do that you cannot do by yourself? You know, because do you need a marketer or do you need a manager? If your music, if you're still a small time artist trying to make a name for yourself, and you say, okay, I'm going to get a manager, then for every deal that you get, you're going to have to pay the manager something. So do you want to split the very small pie that you have, or do you want to say, I'm going to invest in a marketer to extend my brand, and then when I get to a point when I can get a manager, I'll go ahead and do so. So I think those are a few things that I just thought I should mention. Do you guys have any points to make before I get into questions?
Yeah, just to kind of build off those 3 points. So, regarding the process of having a label be interested in you or an artist, this kind of relates to the comments about planning for success, in that you want to make sure that you clarify the rights between the relevant people today, because in a month, a year, or more from now, you may have somebody who wants to be your label and you may want to work with them, but they're not able to work with you because you don't have the rights figured out between the people that were involved. And typically, not to be putting producers in a bad light, and I'm not, but like typically maybe that a producer contributed a lot and now you're no longer on talking terms with them and you're just not able to clarify the rights as between you and the producer or a co-writer, essentially a collaborator. So not producer specifically, but if you were on good terms with a collaborator on kind of day one, use some stuff together, you assume everything will be fine. Fast forward 2 years and you have a label or publisher who wants to no longer on good terms with your collaborator, and you can't come up with the rights as between the collaborators, then you have a problem. And so, I mean, most problems can be fixed with money later on, but that doesn't mean you have it, and that doesn't mean it should happen that way. But yeah, the overall point is to plan for success now before it happens later on. Second point about public performance. So definitely the kind of the 2 main ways that you as a writer earn money from SOCAN or your PRO generally is from when music is performed publicly on like radio, TV, and the other one is actually performing the songs in public, and whether it's you or somebody else performing them. And typically the money that people make from public performance is a lot more than what it should be if everybody actually collected their actual fees. And you can log into your SOCAN and see what performances are not, essentially where the dots haven't connected between performances and you confirming the performance. There's a lot of money that's lost. SOCAN is making it easier for people to let them know about performances that happened. But definitely as an artist who's a writer or co-writer of his or her works, you want to make sure that for every performance you do, when SOCAN is being paid or should be paid, that you are properly informing SOCAN of what happened. And, if you do a performance at a venue or at a festival and SOCAN was not paid, by the promoter or the event, you can essentially say to SOCAN, like, here's a performance I did, and let their membership team handle getting the payment into SOCAN. And that money can definitely add up. It's just one of 100 revenue sources that you need to kind of, as an artist, know about and rely on in order to make it a financially sustainable career. It's a lot of little things adding up, including but not limited to, SOCAN fees from public performances. And the third thing about the manager, for sure, I mean, the thing that we didn't talk about is that a manager can be paid, for example, a fixed fee. Like you can pay a manager essentially a consulting fee with no obligations for royalties. For example, you're paying your manager, for example, like a few $100s a month for as many months as we're working together, and I can stop anytime. So it's essentially like a, lot less risk compared to giving your manager a larger percentage of what you're getting, or any percentage of what you're receiving. And yeah, like totally agree that there are people out there who are experts at every different type of social media promotion. There are publicists, there are radio trackers. There's a whole ecosystem of service providers in music, including lawyers. Like lawyers are service providers in music. And if you don't need a manager, but you need someone to help you with your social presence, hire someone who's a social media music, specialist, a fee for their time to help you. There are companies that get involved with social ad buying. There's just, there's an app for that with people of like anything you'd want in music. So there's that point. And there's also the point that, for a management agreement and just a discussion anyway, you want to make sure you're on the same page with your manager about what he, she, or they are doing. Because if you need them to essentially provide marketing services, but they want to just, figure out how best to get you on some bigger tour, you're completely on different pages about your expectations of each other. So, it goes to the major point of ensuring that you and your manager are on the same page about what you're each doing, how you define success. And yeah, if you need someone to do marketing services, don't hire a general music manager. Figure out who some options are of providing the specific service you need. All really good points, and hopefully the additional comments there are helpful too.
We have some questions at the Q&A
Sure.
section. Can you just take a look at those?
Okay, is using one line from another song considered as sampling? Generally speaking, if you're sampling something, it means you're using any part of the recording itself. So I wouldn't say that, if there's another song that's out there and you take a line from the song, it's not that you can do it. You can't without permission, but I wouldn't call it sampling. It's more like you want to use part of the lyrics. And in that case, you're most protected if you ask for permission. Now, that being said, there's a lot of like generic stuff out there. So if someone has a song and part of the words are, I love you, or like, let's make it, I don't know, like something like generic like that, which could have come from literally like a million songs, there's a little bit less risk there. But if you're taking something that's pretty specific from another song, or like, here's how it's more usually dealt, or the more common situation is that someone is taking a sound or like a beat or a hook from something else. Lyrics are a little bit easier to match. But like if you hear a song, you like the sound and you're like, oh, I'm going to do something that sounds just like that. That's where there's a little bit more risk. I mean, there's risk with both lyrics and using someone else's lyrics, using someone else's sound. So the most conservative thing would be to say that if you're taking anything from somebody else, that you should get permission in writing to do it. And if you're talking about lyrics, if you want to, use someone else's lyrics, whether they wrote it in a book or a magazine article or in a song, you get their permission to do it, and you figure out, what they're being paid for that right. So it's in the same kind of sandbox as sampling. It's not the exact same thing, but it's definitely, the point being that from a legal perspective, if you're using someone else's work on purpose, whether it's on purpose or not, if you're using someone else's work, best case, it's preferable if you get permission from the relevant rights holder in writing in advance of when you do it. Because if someone later on takes a position that you clearly use their line, which is in no other, it's very unique, it was only in their song, their position will be that you infringe their copyright and you owe them something from that song, or otherwise. Linda, do you have anything to add on that question?
Oh, I was just going to say, or they can prevent you from using it. They can, so yeah, it's not just owe them money, but if it infringes on their moral rights, which is, we didn't get into any of that, but if they don't want it associated with what you're doing, it could get tricky. So
yeah, and the related concept there is called an injunction, which is essentially going to a court to get someone to stop doing something. And I usually wouldn't start with that. Usually it would be like a letter from someone like Linda or me that says, it's like a cease and desist, like stop using it.
Or else.
Or else, exactly. Time is of the essence. Like, there's a variety of things people say in those things, but the bottom line is like, we have the right to stop you, so make a deal with us. And then if we agree to the deal, then we'll give you the right to do what you've already been doing from when you started doing it.
And sometimes people just want recognition too. So it's not just they want to be.
They want a credit, and that happens in samples. So like when you're asking for permission to use someone use a sample. On the publishing side of it, like, so if I wrote a song and recorded it and Linda wants to sample it, then, she go to me as a writer and say, I want the right to use this hook or this verse or whatever, or there's just this like part of the song. And I would say, well, I want you to give me, part of my ask would be that I'm listed as a co-writer of the new song that Linda writes. Or it might not be, but like it definitely can be part of that deal. So question says, should an independent record label that's based in Canada be registered with SOCAN? What is the process and under which department does it fall? Publishing ? So a record label doesn't need to be registered with SOCAN as a publisher. It can be if it is playing the role of a publisher with the artists, like the singer-songwriter artists that it works with. And if you are an independent record label and you're looking for a variety of ways to earn money, then one of them might be to actually provide publishing services. You might want to work with a third-party publisher as opposed to being the publisher yourself. So if you are a record label and you have all these artists that you found, that you kind of curated, that you developed, and you want to have a pretty full-on relationship with them. On one end of the spectrum, there might be what's called a 360 deal, where you are kind of getting a percentage of everything. But if you're really kind of sticking in your lane and playing the role of record label, one of the things you might do is that you might ask or contractually receive, be granted rights to be the artist's publisher or co-publisher, as I mentioned earlier. And you might not know anything about publishing, but you might work with some other company who is a publisher, and you might have a deal with some other company. So, other company, independent Canadian publishing company. And if you're looking for some examples, check out the Music Publishers Association of Canada, which is a great organization that works with publishers here. You might try to do a deal with an existing publishing company to kind of bring them the work, the songs that were released by you, have them do all the work. They get things registered. You don't set up a publishing company, they already have one. They collect royalties, they pay you, you take a cut, you pay the writer. So there's a variety of ways that you as a record label, could play a publishing role. You don't need to, and you don't need to have a SOCAN registration if you are not also a publisher. You can, but it's not something generally that you would do. Do you represent independent record labels? Yes, we do. So we help independent record labels with their agreements with their artists. Generally, not always, but like generally, the labels that we work with are some of them are what's called artist-run labels. It's a label that the kind of the key player is their background as being an artist, not being a record label like executive, but they've, kind of developed in their career to a point where they have this sustainable career, but they want to, do more. Other labels that we work with kind of are based kind of all around Canada, do a variety of things. And, without getting into some names of who they are, we help them with their agreements with their artists and also help them with their agreements with other projects that they're working on, including some pretty interesting stuff that we'll promote on our socials, which I will put into the thread. Our little thing here is called Edwards Creative Law. We're on Facebook, Instagram, and LinkedIn. I think we have a Twitter, but we don't really use it. So Facebook, Instagram, and actually, while we go to the next question, I'm just going to share my screen again and go just to something where I forget, which has our contact information here. I'll go to this a second, and I'll just stay on the slide while we answer the next question. So Peter, what's the next question to answer, if any?
Yes. So you guys spoke about the Canadian Intellectual Property Office.
Yeah.
And I would just like you guys to share shed more light onto the importance of this office, what they do, and why it is important for artists to get their music registered. And then secondly, most artists put their music online, and I can almost guarantee that none of them go through the agreements of what they are signing when they're putting their music on various platforms. So from a legal perspective, what risk can they run into, and how can they protect themselves and the music when they are putting their stuff online?
Linda, do you want to start with either one of them, or do you want me to?
No, go ahead, Ben.
Okay, so for CIPO, which is the Canadian Intellectual Property Office, really a key advantage there is that you're creating a presumption that you actually created the work when you said you did it. So if Peter wrote a song today and registered with the Canadian Intellectual Property Office, and I wrote a song a year from now, which is pretty similar to what Peter did, if Peter and I were to be in a legal dispute, the onus would be on me to prove that that I didn't infringe his rights, as opposed to Peter having to prove that I infringed his rights. So if you do register with the Canadian Intellectual Property Office, and by the way, you can register an individual song or a whole album at once. You have the choice. There are some differences, but bottom line, you can register a song or an album. And this is the same thing. Like if you were a computer software person, you can register code. If you're an author, you can register a book or a script. It's dealt with the same way. In Canada, and so the bottom line is that it doesn't trigger copyright, but it gives you that reasonableness. It gives you the presumption that you were the creator when as of the date that you listed in your registration. In Canada, we don't actually send the government anything. We tell them the name, we tell them who owns it, we tell them if it was published yet or not. In the United States, the US Copyright Office, you actually send them the thing. Every time I've ever done it in the US, you upload, like I've uploaded scripts, I've uploaded songs, but like in the US, you actually send them the thing. In Canada, you don't. But that's the big difference. And you're allowed to, Canadians are allowed to register with the US Copyright Office. You don't have to be an American. You can register here and there. But that's definitely a key reason why you would register it. It's really to let the world know that it exists and that you own it and you created it, or that you own it and someone else created it as of a certain time in the context of if and when there's a dispute about who created something. Regarding online, there's a variety of very legitimate digital service providers who get your music up on platforms like TuneCore, DistroKid, CD Baby, like very legitimate companies. And it is important to read the terms of conditions of anything you're doing, online or otherwise. But those are pretty legitimate they are very legitimate companies who get your music up on platforms. The thing that I have the most concern about regarding like online stuff, apart from like online agreements that were written for somebody else that you're relying on to use, the key issue I have is when people are buying beats online or leasing beats online or non-exclusively buying beats online. And the expectation of the artists that I work with anyway are that they can do whatever they want with this beat that they got online. And I say to them, well, send me the agreement and let's talk about what you actually paid for, because what you actually paid for is often not as good, or not like, it doesn't give you the same set of rights that you think you got. And so when people are buying beats off of websites, like every website has a different set of terms. There's different types of beats you can purchase. The concept of leasing it is just a red flag to begin with, because it generally means that you don't have it forever. If you're buying it non-exclusively, that means that there might be 2 or 2,000 other songs with the same beat or melody of the song, which is different. Which apart from like being called out for that, there's issues when it comes to having songs sound alike in the context of these places like YouTube and Spotify, like picking up songs that sound the same, and they may think that you're infringing someone else's copyright, but in fact, you non-exclusively bought a beat that someone else bought. They uploaded it first, and now the internet thinks that you stole their music. So it's a huge issue. I mean, the best case scenario is that you exclusively buy this. Well, best case scenario is that you create everything on your own. Most things aren't created, by the person. People work with other people. Not everybody can create, a melody and a soundtrack and lyrics and perform it. Usually, people work together. Preferably, if you are getting the underlying music or beat from somebody else, preferably it's that you get it exclusively and they're not giving it to anybody else to use. And you just want to watch out for situations whereby you're buying rights to music that you don't actually have the exclusive right to use, or that the creator of the beat can tell you that you no longer have the rights kind of whenever they want to impose that clause in the agreement that lets them buy back the rights. So there's a lot of really problematic agreements that are out there that don't protect the artist who's buying the beat. These websites are legitimate. There's nothing wrong with websites that sell music, like nothing at all wrong with them. It's just that you have to understand what the deal is between you and the company that you're buying from. So, to answer the question about what to watch out for online, it's really not so much, I don't think, like the legitimate companies like DistroKid. It's the companies that sell music that you're buying and you think you have more rights than what you actually do. That's where I would kind of put the higher risk to that kind of stuff. I don't want to be scary. I don't want to scare people, but better that you're kind of aware of something as opposed to it kind of, similar to, so Linda said something early on about investing in music and wanting to make sure that you have the rights before you invest. And situations happen whereby people like record a song, make a music video, put money into marketing something, and then their manager or lawyer or friend or whatever says, wait a second, like, where do you get this beat from? And they're like, oh, I got this from this website. Here's the deal. I spent, $50 or $80 or whatever, got this beat. And someone says, wait a second, like, you can't do any of these things that you're wanting to do because you didn't buy the rights to do that stuff. So before you make an investment in a song, you want to make sure that you actually have the right to do anything you'd ever want to do with that song. So that's, again, something that you preferably hear about in a presentation like this, as opposed to this happening, to you. And while I have the slide open, before I go back to, what we all, for our faces here, I run for the last 5 years. I've run this session called Independent Music Business. It used to be in Ottawa, like in person. Now it's online. Our next session's on March 31st. It's about mental wellness, and so I just had to give a shout out because that's a series that I run. Yeah, so it's called Independent Music Business. If you're watching this after March 31st, there'll hopefully be many more sessions to come. Been around for 5 years and hopefully many more years to come. But on this slide here is our links to our emails for Lindra and myself. If you go to the site, there's a lot of blogs we've written. Again, these are the Instagram and Facebook handles. And yeah, so I'll stop sharing that, go back to us. Any other questions, Peter?
Yes, so there has been a question asked about the prices that lawyers charge and everything,
Sure.
Sort of stuff like that. I don't know if that's something that you want to get into here, or is something that you take offline. I don't know how you handle such a
Sure.
situation.
Well, I think kind of the starting point is that it's a really important thing to know what things cost. And as an independent artist, it's very expensive to be an independent artist, including but not limited to legal fees for stuff. Whether you might be hiring a bunch of people for a lot of things before you're earning any money at all. So it is not an inexpensive experience to be an independent musician. But in terms of legal fees, generally speaking, lawyers charge either an hourly rate, so a fee per hour to do stuff, or a fixed fee to prepare an agreement, for example. So if we have a client who says, well, I want a template to do a certain thing, we'd say, okay, here's the cost to do it. Do you want us to do it? Yes or no? Most of the time, at least for me, most of my time during a day is spent on reviewing agreements that other people wrote, and it's helping out with a variety of other things that come up. And for that time, it's all based on an hourly rate. My hourly rate, today, March 21st, 2021, it's may change in the future, is $295 an hour plus HST or G tax, depending on where you are and depending on where you're located. And that is not, it's not inexpensive to hire a lawyer. The role of a lawyer is to help to make sure that an artist is protected now on things that will last throughout their entire career. So, it's important whether or not an artist can hire a lawyer. It's a good idea to have somebody review an agreement, sign. Just wanted to comment about that. Like some clients that I work with, I might do an hour of work for them every year. Others, it's like a few hours a week. So it really kind of depends on the circumstances. There's no kind of minimum amount that you need to spend on a lawyer. Generally, like if you have one thing you want a lawyer to do, great. If you have, 3 things a month, okay. Like there's no, you don't have to have ongoing stuff in order to have a lawyer, review things for you. But yeah, it's important to proactively understand what the costs are of stuff, including legal services. And, Lindra and I, among other lawyers, try to be as transparent as possible, because we don't want to be in a situation whereby, a client has received services, but not, doesn't have the means or interest to pay them. The last thing I'd say about that is that, generally speaking, what we do, and what I'm assuming a lot of lawyers do, is that they do give a little bit of kind of free time at first to kind of discover what there is to do. So, if someone, for example, wants to set up what we call a discovery call with like myself or Lindra, we give them a link to book a time to speak to us, and there's no cost for that. It's just a matter of us having an initial 15-minute or so call to get a sense of what the legal issue is, and without providing any legal advice, just kind of speaking to what we can do if we are engaged to provide services. So, generally speaking, including with us, you don't need to kind of become a paying client before, we're talking on the phone about something. Usually, like all of the time, almost all of the time, there's, some discussion in advance. What we can't answer is, do I have a good case here for this situation? Like we're not like, lawyers cannot provide legal advice unless we're retained to do so. So, there's that. But most of the time when we start working with somebody, it's because someone's asked them to sign an agreement and they want help to understand, if the agreement is reasonable, if it's within the scope of what's, industry standard, and if it's consistent with what they were told, what's in here that shouldn't be in here, what should be added that's not in here, what should I be thinking about? And that's the kind of service we provide. And many of our clients have managers, many do not have managers. Sometimes when a client does not have a manager, they may ask and just need more help than someone who has a manager. We also work with managers who have a variety of clients. So we can kind of come in for whatever amount of time somebody wants, or to do whatever someone wants to do, as long as it's like within the scope of our practice. And we try to be as transparent as possible about fees, so that everybody's on the same page about the cost, because it is not cheap, but hopefully while not inexpensive, the point is to be valuable. So we want to make sure that we're providing value. It's a lot easier to pay a lawyer if you're signing a deal whereby you're being paid money up front. And when relevant, if an artist has a record label agreement or publishing agreement, one of the things that a lawyer might say is to try to get the label or publisher to pay a legal advance, to essentially pay for the cost of the lawyer. And it's considered as an advance against future sales for the artist, but the artist doesn't have to pay out of pocket for the legal fees, or at least not all of them. So there are ways to reduce your legal costs if you are in an arrangement or looking to sign an agreement whereby the other company involved has the financial resources to cover your legal bill. The next question was about insurance. So there's definitely insurance out there that relates to equipment and touring. If you own expensive equipment, or if you have a studio, you definitely want to be aware of what insurance options there are available to you. And if you want kind of offline, we can connect you with a couple of different options for insurance brokers who focus on music. There's many insurance companies in Canada. A few of them focus on entertainment, and a few of them focus like more narrowly on music. If you're running a music like festival, you definitely want to be aware of the insurance that relates to those types of things. We mostly work with artists, and usually the artists have insurance with respect to like expensive equipment that they own. And for some music grants in Canada, you have to, or at least you did have to get what's called commercial and general liability insurance, because it was just one of the requirements of your grant. So that's the best insurance is an insurance broker. So you want to talk to an insurance broker to get advice about how what policies are out there that would cover what you're doing.
If I may, so I know after artists here get all this information, you can quickly realize that there's a significant cost in being an artist and maintaining your status as an artist, and looking at the creative side of the business while also taking care of the business and making sure they're making money. Thankfully, we are in Canada, and there are various sources of funding from the public that you can take advantage of. However, most artists within our community complain that sometimes they're not really successful in receiving after they've applied for some of these grants. And what I can say is the reason why some of us are not successful is simply because if just straight up, sometimes we don't follow the rules. Because I'm on a few of the panels that I'm a juror for a few panels that give out grants to artists. And in some situations, our artists do not apply, or the rules say you're supposed to apply this way and the application comes in this other way. So even though we may say, okay, we would like to help, your application is disqualified before it even gets to us. We see that you submitted the application, but you've not met all the criteria, so your application is dropped before it is ever looked at. We're going to have another workshop in about 3 weeks' time on the various funding sources and how artists can structure themselves. So that's another topic that you guys may want to listen to, so you can raise funds and be able to hire a lawyer to help you with their career.
Yeah, I mean, I agree. We're very lucky in Canada, among other reasons, to have the music granting system. But as you said, there are challenges, and in general, they're oversubscribed, meaning many more people apply than the available amounts. But getting support from people who are familiar with the granting system is part of the solution. Applying is part of the solution. And advocating and lobbying for more support for people who haven't typically been on the receiving end is very important too. So there's a lot that's out there, but there's a lot more that can be done to make the granting system more accessible and equitable. So agreed. And yeah. If there aren't any other, are there any further questions for now? If not, that's okay. But just want to make sure that if there are, that we answer them.
Well, I mean, you've given out your contact information.
Oh yeah.
And go ahead if you have something to say.
Oh, sorry, it froze for a second on my end, so I was that was technology. So I'm just going to put our emails again here for the first time, I guess, in the chat. Feel free to reach us if you have questions about stuff, or if you're just not sure. If it's not a legal question, that's okay, and we can send you in the direction of someone who may be more relevant to answer. And as I've kind of mentioned a few times, we definitely write a lot of music blogs that are posted for the most part on our website, which is called edwardslaw.ca. And if you go to blogs and click on music, then they're there. And there's other video presentations that we've done as well. So if you just kind of Google or YouTube us and the firm, there's other discussions. There's definitely some overlap, but everyone is different. We really appreciate being part of this program. Support all that you're doing, Peter and team, and wish everyone a successful career. And if there's any way we can help, we'd love to be a part of it. And hopefully there'll be a festival in person in 2022.
Sometime soon,
sooner than later. But done in a safe way, and then we'll all this will be in our past, hopefully. But looking forward to some in-person music. Lindra, any final thoughts for now?
Well, I did want to make one comment or add to a comment that Peter said earlier about SOCAN, and not to forget to register your performances with SOCAN, and you can actually do it retroactively. Don't quote me on how many years they go back. The last time I checked, it was up to 4, but that might have changed. But you can actually go back and advise as to what performances you did, what your set list was, and you never know, there could be royalties out there waiting for you. So that's just my final comment
for today.
Yes. Yeah. Okay. Well, ladies and gentlemen, we've come to the end of the discussion. We thank you guys very much, Byron and Lindra. You guys have been amazing. To all those who have stayed with us, thank you very much for being here. Once again, we'd like to thank our sponsors, TD, Factor, Ontario Creates, Toronto Arts Council, and the Ontario Arts Council. And just to let you guys know that we run this every weekend for the next 4 weekends, exempting the April 4th, which is Easter. I think it's Easter. So we're not going to do anything on that. on that weekend, but every other weekend up until May 2nd, we have a program going. So please make sure that you tell your friends they are free, join us and get more information. Thank you, guys.
Thanks
Thank
very
you.
much, everybody. Take care.
Thank you.
Bye-bye.
Stay safe.
All right.